My name is Tim Wilson. I'm a patent attorney at Dehns, and I specialize in protecting software and electronics and computer-related inventions. And it's my pleasure to speak with you for a few minutes now on this topic of patenting software. Hopefully by the end you may have a better idea of what can be protected through the patent system in the area of software and how and when. I'll talk a little bit about what software is from the Patent Office's perspective, then look at some of the different approaches that countries take, looking particularly a bit at Europe and the United States. And then quite a lot of the talk I'm going to go through some practical case studies, some of them motivated by real experiences that I've had, some more hypothetical, looking at some successes and also looking at some challenges. And hopefully those will help to flesh out this slightly tricky concept of what software can be patented and what software can't by looking at some real examples. And we'll draw it together with some key lessons at the end. And then there'll be a time for some questions and answers. Feel free to type questions into the Q&A box at the bottom of the screen as we go along, but I'll wait to the end to address those. So let's get started. Just as a background, the intellectual property system, a body of law that exists to incentivize and stimulate creativity, and it does that by providing protection that helps to reward the innovation financially that the time and money and effort people put into it. And as you may be aware, there are a number of different areas of legal rights that collectively are called intellectual property rights: copyright, designs, trademarks, patents, and then confidentiality or trade secrets. And software, we're going to talk particularly about patents, but copyright and confidentiality and to some extent designs can also have a role to play in protecting computer-related inventions. So I'll touch very briefly on copyright first. Copyright you'll be familiar with from photography and films and music and literature, but it can also be used to protect computer code, both raw source code in a language like Java or C, as well as the compiled object code, the executable file that gets loaded onto a computer. However, copyright is a relatively narrow way of protecting software because it would require evidence that somebody has actually copied a chunk of code to find infringement. On the plus side, you get copyright protection automatically, no registration is required. So it can be useful, and there have been situations where copyright has been helpful for software matters. But we're going to talk mainly about patents, which are a more powerful right potentially when they apply. So patents have been around for several hundred years, originally being used to protect things like the formulation of stained glass windows, and a long history in the fields of engineering and chemistry and science. Obviously, computer software has come along as a relative newcomer, and patent offices have struggled a little bit to work out how to classify it and how to fit it in with the patent system and what protection to afford it. And different countries have found different approaches, and those approaches are changing. They're still changing over time in some countries. But fundamentally, the patent system exists to protect new solutions to technical problems, engineering, science, those sort of areas, as opposed to artistic or commercial endeavors. Patents have to be applied for. That process can last for several years, during which you have a patent pending phase, which can itself be useful as a deterrent, and for licensing and funding and so forth. The ultimate hope, though, obviously, is to get a granted patent, which gives that assurance and protection against somebody copying your creative activity, your inventions. But because patents are quite powerful, they protect a concept rather than just a particular instance of something, and they don't have to prove copying. There are some requirements that have to be met. You have to show that your idea is new, that no one's ever had it before or published it before, and that it's not obvious, it has an inventive step. And there are also exclusions written into the laws of some countries, and computer programs is one of those ones where there are some exclusions that have to be borne in mind. So first of all, what do we mean by software in the context of the patent system? It's a very broad concept here. When we're thinking about computer programs or software, a computer would be anything that contains a processor, a CPU or a digital signal processor, and that has memory and some inputs and some outputs. And by software, I simply mean a list of instructions that tell a processor what to do. They implement some sort of algorithm and would be stored in memory of the device. So that could be a conventional desktop computer or laptop running a software like Microsoft Word, but it could also be embedded firmware in an appliance like a washing machine. It could be an algorithm for image processing or data compression, or it could be an analysis system for a medical scanner, or a whole range of different areas, wherever instructions are being executed by a processor. There's the potential for patentable inventions. But as I mentioned, different countries have taken different approaches to computer programs, and at the European Patent Office, the European Patent Convention has in its rules that computer programs are excluded from patentability as such. But the key phrase there is this "as such," and that means that the exclusion is quite narrow. And as long as you've got something that's more than a pure computer program, then you're usually okay in Europe. But that exception has led to some misconceptions that are commonly held that you can't patent software at all, and that's certainly not the case. But there does have to be a technical invention, is how the European Patent Office will look at it, and they need to say, they'll say, is there a technical solution here to a technical problem? And we'll think a bit more with some examples as to what that means in practice. But here are a few signposts that the courts, this is a UK court in this case, have given as to when software might be seen as technical and therefore patentable. It may be if it has a technical effect on a process outside the computer, if it controls traffic lights, for example, or if it has a technical effect at the level of the computer architecture, for example, in how memory is used within a computer efficiently, or if it makes a computer operate in a new way to do something completely different, or if it improves the computer itself to make it faster or more reliable or more secure or using less energy. Those are all the sort of things that could be technical. For example, a concept for a computer game, maybe a concept to fire angry birds at pigs, is computer software. It makes a screen operate, it receives inputs, it processes data. However, at that level of generality, that wouldn't be seen as technical in Europe. The concept of firing angry birds at pigs would be seen as a non-technical game concept. So what is technical? Here's a little analogy which some people have found helpful. So instead of a computer for a moment, think of something, a simpler machine, a programmable knitting machine. You give it some instructions and it gets to work and can build a scarf or a jumper for you. The machine itself, when that was first developed, could well be patentable as an engineering invention. But what about the patterns, the new instructions? Maybe you feed it some punch cards with some instructions and it gets to work making a new scarf. You might design a new scarf that has some different colourful features and looks pretty that no one's ever developed before, but that's not going to be protectable through a patent system. It would be an aesthetic development rather than a technical innovation. So you might think, well, you couldn't ever patent the programs, the punch cards. But what if you came up with a new type of knot that this machine can make that creates a scarf that's more insulating for the same amount of wool than ever before, or that makes a jumper that's more resistant to tearing? It's possible that you could then say that has a technical effect, and that any patents that implement that new knot could be patentable. Or maybe you find a way of actually making the machine itself work better to become a better machine. If you think back to those signposts, slightly contrived, but perhaps you find that a particular order of instructions for the needles causes them to operate with lower energy consumption. They work at a resonant frequency and use less electricity. So you've made it a better knitting machine. Again, you might be able to argue that all patents that implement that idea should be protected by a patent claim. So it's a sort of simplistic analogy, but it gets somewhat to the idea of software that makes a machine work better or have some effect in the outside world, a better insulating jumper as the product of it. May be patentable, but something that's simply aesthetic is not going to be. So what about elsewhere? The United States has no legal exclusion in the way that the European system does against computer programs, and historically has been more permissive to patenting computer software. However, in the last decade or so, there have been a number of legal decisions in courts in the United States with names like Bilski and Alice and Mayo, which have restricted down somewhat what can be patented. So certainly in the areas of business methods and computer software, it's now much harder to get things patented at the US Patent Office than it would have been 10 or more years ago. And the Mayo decision has led to this approach of the Patent Office asking if there is significantly more in a software invention than simply an abstract idea. In practice, it's more convergent now with the longer standing approach in Europe. And in fact, in a few cases, it can even be harsher. I've had cases where we've had patents granted in Europe and struggled more in the United States. So some areas where this abstract idea objection might get raised would be if you're doing something that's quite mathematical and algorithmic, or if you're using software for diagnostic methods. There can be challenges there. There are ways to try and mitigate those, but it can be more complex than it was in the past. Briefly, elsewhere, Japan is fairly permissive as long as you have something inventive. China is similar to Europe. Australia and the United Kingdom need a technical contribution, which again is somewhat similar to the European approach. Canada is relatively permissive about software inventions, but somewhere like India is very strict in the other way, and there has to be some new hardware components and not just purely software. So approaches differ is the main thing to take away from that, and that can make it complex because you're often at the edge of what can or can't be allowed. So to give a few more examples to help you assess whether ideas that you've got in software field might be worth exploring patent protection, here are a few case studies. So let's have a look at a few of those. So here's something that may well be patentable, some new feature on an embedded operating system. Perhaps you've developed a way to control program flow between firmware or an operating system and some application software, managing interrupts and calls between them in a way that is particularly secure and protects the device from hacking or from programming errors. And I've worked on inventions like that and had those patented in Europe and the US and elsewhere. User interfaces can be a bit trickier if it's closer to a sort of an aesthetic concept of what a graphical user interface might look like. But I've had examples where there's been some new type of user interaction. In one case, for example, using a tracking of hand gestures, and then a way to control the user interface to make it flow and respond more naturally to a hand type gesture of a sweep or a tap of items zooming as you approach them to tap them, for example. That sort of idea is not purely aesthetic, we can argue, but actually improves the technical functioning of the device to make it more usable. And those ideas we've had success in patenting. Something where it might be harder, and there's a case that motivates this that I have in mind at the European Patent Office, where we had a social network, a little bit like LinkedIn or Facebook, where users are connected, but they don't necessarily see each other. And this social network could broker introductions between people who were separated by 3 or 4 different degrees of separation. And a patent examiner objected that this was merely automating existing human social interactions, and that it wasn't a technical invention. And we argued that that wasn't actually the case. There was no human analog where you could actually get introduced to somebody because there were 3 or 4 indirect links of people between you and them, because there's no way of discovering that in normal human interaction. It was only because a computer had on its database all of the interactions and network connections between all of the users that it was able to see that you were 3 steps removed from somebody else and could then broker an introduction. So we argued hard that there was a new technical solution here through the existence of this network database structure. But unfortunately, the patent examiner wasn't persuaded in that case, and so eventually the applicant decided not to push it further. But it was a bit borderline. Something else that may well be patentable is a payment system here, in this case a biometric one, where you have a fingerprint scanner on a bank card, for example. The hardware for putting a scanner on a bank card is certainly patentable, but also the software algorithms behind recognizing a fingerprint on a low resource device for using that to secure payments on the back end. Those are technical innovations that could be potentially patented. Medical scanners, another area where I've done quite a bit of work on ultrasound and MRI and other sort of scanning systems. If you use software to process medical images to make them more useful to clinicians, then those sort of things can well be patentable. There can be a challenge if it's closer to medical diagnosis. Some countries have restrictions on making diagnoses on a patient, but if the innovation lies in the actual image processing or the software more, then those sort of ideas can certainly be protected in the patent system. Here's an example of a hypothetical one of something that may not be patentable. Suppose you had a new website, and the idea you have is to allow people to plan a journey, maybe from Oxford to Edinburgh, and they want to go on the lowest cost possible. And so it's a ticket searching service that will split the journey between different modes of transport, and maybe suggest you get the bus up to Manchester and the train from Manchester to Edinburgh, and that's the cheapest way that you could get there if you're willing to change transport modalities. It could well be a good concept for a business, and it may be that no one's ever done it before, but it's likely to face objections from a patent examiner that the actual way the website operates, the databases of tickets and the use of algorithms to find the lowest cost journey are conventional algorithms, and they've simply been put together to give a new business offering, but not actually solving any new technical problems. So that might be harder to patent. Another one that might be harder is an electronic slot machine concept, where a one-armed bandit on a screen, and an idea that that maybe the display reveals some information about what number's going to come up next before it's fully appeared on the screen. That it uses technical means to implement the idea, but it could struggle to be patented, at least in Europe, on the grounds that it's actually just adding to the gameplay rather than solving a technical problem on the way the software operates. However, we have had some successes on something that seems quite similar, but patented in Europe, a networked gaming machine where it was a poker playing game where a server would generate some cards for a hand of poker to be displayed on the terminal, and the user could select some cards to stick with, and the server would then generate future hands with those cards present in the hands. Again, it might sound a bit similar that it's a sort of gameplay idea, but because we had this interaction of data packets being sent backwards and forwards between a client device and the server, encoding the hand and the cards that were to be kept or not, and it controlled the server's behavior and the client terminal's behavior in a new way. We managed to argue successfully that that was a technical innovation and got that patented. Another example, I've had a few inquiries over the years of people who are using blockchain for various different purposes. So hypothetical example, suppose someone's come up with the idea of using blockchain for a document audit on maybe medical prescriptions, so that they can be tracked as they go from the doctor to the patient to the pharmacy, back to the government's databases, and blockchain can secure that. It may be that no one's thought to use blockchain for medical prescriptions before. However, if the way that they do that is using an off-the-shelf blockchain software, then the Patent Office is probably going to say that it's a business innovation rather than a technical innovation. If, however, the actual blockchain algorithms, the cryptographic protocols or primitives have been modified or adapted in some way, then that may be more promising for there being a technical innovation that could be patented. So that was a quick whiz through just a few examples of some case studies to show that some software can be patented, some would be harder to patent, and some it's a bit borderline and difficult to judge one way or another, and it may be different in different countries. So some key lessons to take away. The law, as I've mentioned, is quite complex in the area of software and evolving. As something like machine learning comes much more prominent, and artificial intelligence inventions are coming up. Again, some of the approaches are developing there, and they can differ in patent offices around the world. But a key question which is useful to ask wherever you're looking and applies generally to countries is whether there's fundamentally been an engineering innovation in the software that you've developed, or is it only a business or a commercial innovation? Some pointers to there being an engineering innovation would be if the software or the algorithm solves a technical problem in the physical world, maybe control software for a manufacturing process, or if it improves the operating of a machine. Somehow it's faster machine, or works better or more efficiently or more securely. Those would be pointers towards an engineering innovation. Whereas a purely business innovation may be where conventional technology has been applied to a new industry or business, where the actual programming, if you gave the product specification to a software developer, could be done using routine software engineering techniques without any difficult problems having to be addressed. Or if you're automating a process that's traditionally done manually, maybe an accounting process that's now done with software, but the way that's been implemented is replicating the manual process. But if you're in doubt and you'd like advice, it's worth assuming that software may be patentable. The sort of broad brush approach that you can't patent software is certainly not the case, and I hope that's been demonstrated today. And so would advise you to seek professional advice if you think there might be something that's worth protecting. So we've got time for a few questions. So if you'd like to type any into the question and answer box, then I'm happy to spend a few minutes addressing those. If I don't have time to get to them, I follow up by email afterwards. So we've got a question here that says, given that software is mostly hidden, how often does one keep it hidden as know-how rather than publish it? That's a really good question, and it can depend on a number of factors, but a key one is probably where the software is going to be deployed. If you're delivering software shrink wrapped, people don't tend to give out software on CD-ROMs these days, but if it's downloaded from an app store and run on a user's device, or if it's installed on a customer's computer, then it's very difficult technically to rely on obfuscation and encryption and security methods to prevent people from reverse engineering software. So it would be reasonable to assume that anybody, or even to rely on legal methods of agreements, people can and possibly will, and competitors will, reverse engineer software and discover how it's working. So in that case, the patent system can well be useful to protect it. However, if the software is operating as a service and hosted on a cloud or a server which you retain control of, then there's certainly the potential more to keep some of the know-how and ways that it operates confidential. So, for example, a search algorithm that Google runs, they could well keep secret and not want to patent or publish. Yeah, there are some other considerations that could be important to look at there. But in general, I would suggest, where is the software? If you're keeping it, then it could be a better candidate to keep secret. But if you're releasing it, then the patent system is useful. Another question: is there a difference between technical effect and technical contribution? Probably not at the level that we're talking here of assessing whether it's worth pursuing a patent application or not. Technical contribution is a term that the UK courts have used. A technical effect is the language that the European Patent Office uses, but the UK and European approaches are meant to be harmonised. So although there are some slight subtleties in how they assess software, the UK is broadly likely to find something patentable if the European Patent Office would, and vice versa. Another question, and then probably wrap it up there, although they do keep sending questions in if you've got more, was about, I think it's probably similar a little bit to the first one about whether to keep it hidden or not, about territory. So patents are a territorial right in one country, but what if my software could be hosted anywhere? That's another good question. So obviously, if you're providing software as a service, then what country you have the server on could be quite flexible, and so would you have to get patents in all of those possible countries? So the answer is hopefully not, although it does come down a little bit to how the patent claims are worded. But there have been decisions in both the UK and the United States that I'm aware of that have broadly shown that if the benefit of a server-hosted software is derived in the country in which the patent is held, so in the UK or in the US, for example, then infringement can be found, even though some of the methods of the system is located in a completely different country. Time for one more question. What about simulation software, where there's an additional step between running the software and the technical effect outside the computer? So simulation is obviously a very interesting area, and a lot of modeling and simulation and sort of digital twin type ideas are being used in whole areas of drug discovery or in engineering design. So I'm not exactly sure what additional step you have in mind, but there's actually a decision that's gone to the highest level at the European Patent Office that should be decided on next week, about a simulation software simulating the flow of people through a building, in terms of architecturally designing public buildings, and whether or not software that simulates the flow of and movement of people is technical and should be patentable or not. So the outcome of that decision will make quite an effect for Europe. But certainly if you're modeling a technical process and you're using that model to change something technical in the real world, then both of those would be pointers I would think towards it being worth trying to patent the software. So I think that's hopefully addressed those questions, but any of the people who ask those questions, if you'd like more details, please do feel free to come back to me by email later. My details are on the screen, or if anyone else has any questions, please do contact me and ask. I'd be happy to speak with you afterwards. So now I think my colleague Michelle is going to talk to you a little bit about a few upcoming events. So over to you, Michelle.
Thanks very much. Hi everyone, thanks for attending today, and thank you, Tim, for presenting. As part of our summer webinar series, we're hosting a webinar each week during July and August on Thursdays. Next week's webinar will cover the patenting of medical and biotech inventions, and the following week we'll take an introductory look at protecting your designs, and the week thereafter we'll have an introductory look at trademarks. So I will send the registration links for these webinars in the follow-up email to this webinar, and shortly you'll be able to register for all of our webinars on our website. We've also delved into the world of podcasts. So we've just launched the IP podcast. We've had about 5 episodes so far. So do take a listen. You can search for Dehns on Spotify, iTunes, and Google Podcasts. But that's it from us for today. So as Tim said, if you have any more questions, please just email us and we'll be in contact. And also if you have any topics you'd like us to address in future webinars, just drop us a line. Thanks everyone. Thanks, Tim. Bye.
Thank you.